Hello and welcome to ProfDale's Property Video number 17. I'm your host, Dale Whitman, and the subject of this video is severance of joint tenancies. So what do we mean by a severance? Well, the first thing to understand is that the concept of severance applies only to joint tenancies with right of survivorship. For example, there's no such thing as a severance of a tenancy in common. Only a joint tenancy with right of survivorship can be severed. What happens in a severance is that one of the joint tenants conveys his or her interest to an outsider, and by an outsider we mean somebody who wasn't part of the original group of joint tenants. When that happens, it breaks the unity of time and title with respect to the interest that goes to the outsider. In other words, they don't have unity of time or unity of title with the insider or insiders, the people who are left in the original group. The result is that the interest that goes to the outsider can't be a joint tenancy with right of survivorship because it doesn't have the four unities that we talked about in the previous video. So that interest, the interest that goes to the outsider, becomes a tenancy in common interest instead. Now, before we give an illustration of that, let me give you a hint. Don't get severance mixed up with partition. We haven't talked about partition yet. We're going to cover it in the next video. But the words severance and partition sort of sound alike, as if they were describing the same thing. In fact, they don't describe the same thing at all. The concept of partition applies to both joint tenancies with right of survivorship and tenancies in common. So be very careful not to mix up the two. They're very distinct. Let's take a simple example of a severance. Let's suppose that Harry and Wilma, husband and wife, own property as joint tenants with right of survivorship. They may have bought it in that form. Let's suppose it's their house and they took title as joint tenants. Or it's possible that one of them was the owner of the house and conveyed it to the two of them as joint tenants with right of survivorship. In any event, that's what they have. Now let's suppose that later Wilma delivers a deed to her son Walter. What will the deed pass to Walter? Well, Wilma only has a half interest, and so the deed conveys Wilma's half interest to Walter. Walter now has a 50% interest in the property, but Walter, because he's not part of the original group, there's a severance and Walter's interest is automatically converted into a tenancy in common. The result, of course, is that Harry's interest is also now a tenancy in common because it's the only other interest in existence. And if one of the two owners has only a tenancy in common, the other one must have a tenancy in common as well. Now, there's no more right of survivorship in a tenancy in common, of course. So the result is that if Wilma later dies and Harry survives, Harry will still have only a half interest in the property. If the severance hadn't occurred and there was still a joint tenancy, Harry, of course, upon Wilma's death would have a 100% interest. But because of the severance, Harry only gets a 50% interest, and that's all Harry will have when Wilma passes away. Now, there are several factors that we might suspect would be relevant to deciding if a severance occurs, but in fact, they turn out not to be relevant at all. Let's look at some of those factors. Suppose Harry doesn't consent to the severance. He doesn't want a severance to occur. Perhaps he thinks he's going to survive Wilma and he'd like to get all of the property. But Harry's consent doesn't matter. His consent isn't necessary for the severance to occur. In fact, it's not even necessary that Harry have any notice of the severance. He might not be aware of it when it occurs, and in fact, Harry might not find out about it until after Wilma dies. But the severance is still effective. The deed that causes the severance doesn't need to be recorded in the public records. There are other reasons for recording a deed in the public records, but the severance is not among them. The severance occurs whether or not a recording of the deed is going to happen. Finally, it doesn't matter whether the deed that causes the severance is a quitclaim deed, one that contains no covenants or warranties of title, or a warranty deed that does contain warranties or covenants of title. Either way, the deed will cause a severance. Now things get a little more interesting if there are more than two joint tenants. Let's suppose there are 3 or 4. After all, there's no limit on the number of joint tenants that we can have. So the first thing to realize is that only the interest that's conveyed to the outsider is severed. The remaining insiders still have a right of survivorship among themselves. Let's take a look at an example of that. Let's suppose A, B, and C are joint tenants with right of survivorship, and A makes a deed to X. What interest do the parties hold now? Well, the answer, of course, is that the interest that was conveyed to X has become a tenancy in common interest, but the interests that are still held by B and C still have a right of survivorship among themselves. So if B dies, then X still has that 1/3 as a tenancy in common, but C, by virtue of the right of survivorship that C had with B, now has the other 2/3 as a tenant in common with X. You'll notice that because B died before C did, and B was in a joint tenancy with a right of survivorship, B's heirs or devisees have nothing. B can't pass anything by his will or by inheritance because his interest terminates when B dies. So remember that only the share that's conveyed to the outsider is severed. The insider shares continue to have a right of survivorship among themselves. Now, we are absolutely sure that if one of the joint tenants conveys by deed to an outsider, that will sever the joint tenancy. But we might ask ourselves, are there other kinds of conveyances besides a deed that will sever a joint tenancy if one of the joint tenants passes it to an outsider? What about, for example, an agreement among all the joint tenants to hold as tenants in common instead? Well, technically, at common law, that wouldn't work, but today nearly all courts would say, sure, if the parties have all expressed their mutual understanding that they will now hold as tenants in common, well, the court ought to enforce that. So that one is almost certain to occur in modern times. What about a contract of sale that's only signed by one party? Now, you might say that's a little bit strange. Why would anybody want to buy just one party's interest in a piece of real estate? But nevertheless, sometimes one party will sign a contract of sale without the other one joining. What happens then, of course, is that now the two co-owners stand on somewhat different footings. One of them has obligated himself or herself to transfer the property under the contract, and the other has not so obligated himself or herself. So the result is that they're thought of as being not on the same footing, not having the same exact title, and therefore the unity of title is broken, and therefore a court is likely to say that that's enough to sever the joint tenancy. Now, on the other hand, if there's a contract of sale that's signed by both parties, and that of course is much more likely because a buyer is almost certain to want the interest of both parties, if they both sign the contract, then they're on an identical footing. Both of them are under the same obligation. There's no difference in the titles that the two of them have, and therefore the court is likely to say that in this case there is no severance by virtue of signing the contract. What about a divorce if the joint tenants are married? Well, a divorce in and of itself, the courts are almost certain to say, will not sever the joint tenancy. They still own what they owned before the divorce. However, you've got to read the divorce decree if it's signed by a judge, or the settlement agreement if the parties enter into it without the judge's approval, to see what it might say about the property. And very often the decree or the settlement agreement will provide that the joint tenancy will no longer exist and will be converted into a tenancy in common instead. Finally, what about conveyances of more limited kinds of interest, such as a life estate? Will a life estate conveyed by one of the joint tenants sever the joint tenancy? There's very little authority, but the answer is probably no. It probably will not be considered to be enough like a full-fledged deed that conveys a fee simple interest. The same is true if one of the parties enters into a lease of their interest while they're holding as joint tenants with right of survivorship. The chances are a court will say the lease is not a big enough conveyance to sever the joint tenancy, and it continues then to have a right of survivorship. One of the most interesting questions is whether a mortgage that's signed by only one joint tenant will sever the joint tenancy. What do we mean by a mortgage? Well, a mortgage is an interest in land that's transferred to a lender as security for repayment of a debt. The person who borrows the money is called the mortgagor, as you can see in the picture here. And the mortgagor actually signs two different documents when they borrow the money. They sign a promissory note promising to repay the loan, and then they sign the mortgage, which gives the lender an interest in the real estate as collateral or security for repayment of the debt. How does the lender use the security? Well, if the mortgagor or borrower fails to make the payments on the note as required, then the lender can take the mortgage and use it to have the real estate sold and use the proceeds of that sale to apply toward the delinquent debt. Now, the question before us is whether the mortgage passes title to the land. In other words, is the mortgage like a deed? We already know from our previous discussion that a deed executed by only one of the two joint tenants would sever the joint tenancy. Will a mortgage be enough like a deed that it also will sever the joint tenancy? Well, the answer depends on the jurisdiction, and there are two different theories of mortgage law that are prevalent in the United States. The first one is called the title theory of mortgages. It's followed in about 20 states, mostly in the northeastern U.S., and what it says is that a mortgage transfers the mortgagor's title to the land to the lender or mortgagee. The other theory is called the lien theory of mortgages. It's followed in more states, about 30, and what it says is that a mortgage doesn't transfer title to the mortgagee, but it only gives the mortgagee a lien, that is, the right to have the property sold in order to pay the debt. So if you're going to ask whether a mortgage by one joint tenant will sever the joint tenancy, you first have to answer that question by looking at the mortgage law of the particular state that you're in to see whether it follows the title theory or the lien theory of mortgages. Now let's see how these two theories play out. If we're in a title theory state, a state that says a mortgage is like a deed and passes title to the land, then a mortgage by one joint tenant alone will cause a severance, just as a deed would cause a severance. In lien theory states, on the other hand, a mortgage by one joint tenant isn't enough like a deed, and it doesn't cause a severance to occur. Let's look at this in the form of a concrete example. Remember Harry and Wilma, who were married and held property as joint tenants with right of survivorship. Let's suppose that Harry, alone, all by himself, executes a mortgage to a bank. Harry borrows some money and gives the mortgage as collateral for his repayment. By the way, the bank is acting rather foolishly here because smart banks always insist that all of the joint tenants sign a mortgage that they're taking on the land, so they'll avoid the problem that we're about to experience here. Nevertheless, this bank takes only Harry's interest in the land. As a result, if we're in a title theory state, a state that considers the mortgage to be like a deed, there's a severance of the joint tenancy. And that means that the bank now has a valid mortgage, but it's only a mortgage on a half interest in the land. In effect, the bank has a mortgage on a tenancy in common interest. In the lien theory states, on the other hand, there is no severance, and that means there's still a right of survivorship. So now we have to look and see who survives. If Harry dies first, the bank has a lien on nothing. Harry's interest simply terminates. It's extinguished if Harry dies first in a right of survivorship situation, so the bank has a lien on no interest at all. On the other hand, if Wilma dies first, then Harry is the survivor. The bank took its mortgage on Harry's interest, and Harry's interest has now become a 100% interest by virtue of the right of survivorship, and therefore the bank has a lien on the entire interest. Let's consider one last severance issue. What about a judgment lien against only one of the joint tenants? What in the world is a judgment lien? Well, let me explain. Suppose Harry and Wilma own land as joint tenants with right of survivorship. Harry, all by himself, is sued by a finance company. Harry owes some money to the finance company, and it gets a judgment against Harry. Now we're assuming that Wilma doesn't even owe any money to the finance company, and therefore there's no judgment against her. Once a judgment is entered against Harry, the judgment becomes a lien on all of Harry's real estate. In some states, in order for the lien to take effect, all that's necessary is for the judgment to be docketed in the court records. In other states, it has to be recorded in the real property records as well. But one way or another, the judgment becomes a lien on all of Harry's real estate. Well, what's the effect of that on this particular real estate that's held in joint tenancy with right of survivorship? Well, a judgment lien won't sever a joint tenancy with right of survivorship. It's similar to a mortgage in a state that follows the lien theory of mortgages. In effect, what we're saying is that a mortgage may or may not be considered a lien, depending on the state we're in. We talked about that on the previous slide. But a judgment lien is always just a lien, and it will never sever a joint tenancy with right of survivorship, not in any state. The result is that there's still a right of survivorship. So if Harry dies first and Wilma survives, the finance company has no lien at all because it was a lien on only Harry's interest, and Harry's interest has been extinguished by the right of survivorship. On the other hand, if Wilma dies first, the finance company has gotten lucky now. It now has a lien on a 100% interest in the property because that's the amount of interest that Harry owns once Wilma dies. Again, under that right of survivorship. Now we need to take a look at a different kind of arrangement that's similar to a joint tenancy with right of survivorship. In fact, it looks exactly like a joint tenancy with right of survivorship, but when we examine it closely, we'll see that it is not. Let's consider the following two forms of conveyance. The first one is one we've already talked about at length. It just says to A and B as joint tenants with right of survivorship, a conventional joint tenancy with right of survivorship. The other one is worded a little differently. It says to A and B as tenants in common for their joint lives, remainder to the survivor of A and B. Now when we look at that, we say, well, it looks like it would produce exactly the same result as a joint tenancy with right of survivorship. Both parties own it with a 50% interest each during their lifetimes, and then when one of them dies, the other ends up owning all of the property. So the two forms of conveyance seem quite similar. Let's take a closer look at the second of the two forms of conveyance on the previous slide. That's the one that said to A and B as tenants in common for their joint lives, remainder to the survivor. What interest does each owner hold under that form of conveyance? Well, the first thing that each of them has is a half interest in the land by way of a life estate, or in other words, for life. But whose life is the measuring life? Well, it says their joint lives, which means as long as they're both alive. So as a practical matter, the life estate will end when the first of the two to die passes away. In other words, it's a life estate for the life of the first to die. That's not the only interest they have, though. Each of them also has a contingent remainder. The reason it's a contingent remainder is that there is a condition precedent or precedent that has to be satisfied. And what is the condition precedent? As to each of them, the condition precedent is surviving the other cotenant. So if A survives B, A will take the contingent remainder in possession. If B survives A, B will take the contingent remainder in possession. Now remember, on the previous slides we learned that in an ordinary joint tenancy with right of survivorship, there can be a severance if one of the parties conveys to an outsider. Let's see what happens if there's a conveyance to an outsider by one of the parties in this form of ownership, which isn't quite the same as a joint tenancy with right of survivorship. What happens is that each party's remainder is not severable and is unaffected by a transfer by the other party during their joint lives. So, for example, if A makes a transfer to an outsider, nevertheless, if B is the survivor of A and B, in other words, B outlives A, B will take the property upon A's death. And of course, vice versa is true as well. If B makes a conveyance to an outsider, but A survives, A will take the entire property upon B's death. So the result is that unlike a joint tenancy with right of survivorship, a conveyance to an outsider doesn't wipe out what is in effect a right of survivorship. Is this different than a standard joint tenancy with right of survivorship? Well, it certainly is. In effect, what we've got is something that's similar to a joint tenancy with right of survivorship, except it can't be severed, and no action by one of the parties can take away the other's right of survivorship. Now, which is preferable in terms of the grantor's intent? Which do most people wish to create when they give a couple of parties a joint tenancy with right of survivorship? Well, there's no generic answer to that question, but a wise lawyer would sit down with a client who's giving a joint tenancy with right of survivorship and explain the implications of both forms of transfer and ask the client which they prefer. Do they want to allow a severance to occur and the right of survivorship to be wiped out by a conveyance by one of the parties, or do they not wish to have that happen? They can do it either way by appropriate language. Now we're going to wind up this video by talking about weird conveyances, conveyances that are ambiguous because they don't follow any of the standard forms that we've already talked about. You can't really quite tell if they intended a joint tenancy with right of survivorship or a tenancy in common or something else. I'll just throw up a few examples, but you can think of dozens of possible examples. The non-standard wording might read something like this: to A and B jointly and to the survivor. You'll notice that's not the same as saying to A and B as joint tenants with right of survivorship. Another example, to A and B and the survivor of them. Another example, to A and B, this is one of my favorites, as joint tenants in common. Well, there's no such thing as joint tenants in common. None of these forms are standard forms of conveyance, and so it's hard to know what to do with them. Here's one more at the top of the slide. The grantor says, I grant my land to Alan and Betty jointly with rights to the survivor. Now, you have to be precise about this, and if you're precise, you'll say, that's not quite the same as saying to Alan and Betty as joint tenants with right of survivorship. It's non-standard language. What do you do with it? Well, if you should encounter language like this on an examination, what you want to do is think of the three possible ways of interpreting it. What are the three ways? Well, one possibility is to say, it's not exactly a joint tenancy with right of survivorship, but it's pretty close and maybe close enough that a court will consider it to be a normal joint tenancy with right of survivorship. A second possibility is that a court will find it's a tenancy in common for life with a contingent remainder to the survivor. That doesn't require quite the same precise language as a joint tenancy with right of survivorship, and maybe this language is close enough that a court would choose that interpretation. A third possibility is that it doesn't fit either one of these in the court's mind, and therefore the court will go with the default interpretation that it's simply a tenancy in common in fee simple. Now, I'm not sure what the right answer is here, but I know what you ought to do if you get this on an exam. You want to analyze the language to see which of those three possible interpretations it fits best. For example, it does use the word jointly, and it does use the word survivor, and so chances are it could be either number one or number two. But what you want to do on an examination is to be sure and consider and discuss all three possibilities. Probably the grade you get on your exam will have little or nothing to do with the outcome that you choose, but it will have everything to do with your ability to recognize the three possibilities and make some plausible argument about which of the three categories the language will be fit into. That winds up our discussion of severance of joint tenancies. In our next video, we'll talk about rights among the cotenants. If you have questions or comments, email ProfDale01@gmail.com. Thanks for watching.